joined by Mr. Harish Salve. Needs no introduction. India's top-notch legal eagle and, of course, the former SG of India. Thank you very much, Mr. Salve, for speaking to us on a day full of implications, really, for judicial transparency. Mr. Salve, your assessment of the response of the Supreme Court collegium in the first instance?
My response is, I'm afraid to say, very negative. And it's for a reason. The allegations, and I only call them allegations, I have no information beyond what I've read in the newspaper. So I caveat it. But if the allegations are true, and the fact that the Supreme Court has considered it necessary to act, then what should have been the response? And the response has established things which critics of the collegium system like me have always said, that this system doesn't work. Today, this is not a case where there are some internal complaints against the working of a judge, and in order to ensure that judicial independence and integrity is not compromised, you do an in-house inquiry. Today, this complaint is that, as per the newspapers, the fire brigade and the police went into the judge's home to rescue it from a fire and found large sums of cash. Now, if this is true, it's something which has happened in public. And I have 2 or 3 reasons for which I feel this collegium decision is deeply flawed. If this had been found, Rahul, in your house, if such a large money would have been found in your house, by now the ED would have been at your doorstep. If this money had been found at the house of the Home Secretary, Finance Secretary, Transport Secretary, would they have been transferred to another department? They would have been suspended and a disciplinary inquiry commenced. Perish the thought, if this had been found in the home of a cabinet minister or a state minister, what would have happened? People would have been paying for their blood. You would have been asking right now, why has he not been arrested? And if the government had said, we will do an in-house inquiry into the cabinet minister, the Supreme Court would have interfered on a PIL, constituted an SIT and a supervised investigation. Are those same standards to be applied to one of your own? I would say higher standards need to be applied to one of your own. So it's wrong at that level. It's wrong at a second level because this is not, I believe, an in-house inquiry has now been ordered.
Yeah.
This is not fit for an in-house inquiry. Third, why are you transferring this judge? If he is fit to discharge judicial functions, let him be in Delhi. And if he is unfit to discharge judicial functions pending this cloud, till the cloud is either removed or confirmed, is he fit for Allahabad High Court but not for Delhi High Court? What is Allahabad High Court? A dumping ground? So, and this notion that we are sending him to his parent High Court, he didn't come on a promotion to Delhi. Allahabad High Court is a co-equal institution and he was a judge of a co-equal institution. It is moving a judge from one court to the other. We are always told, this is not a punishment. It's just a convenient arrangement of dispensing justice. So if he can't dispense justice in Delhi, how does it solve the problem by transferring him to Allahabad? So it is wrong at so many levels. I mean, Allahabad High Court is not a dustbin for judges of doubtful integrity. And if he is not of doubtful integrity, you have all the facts. You, in the sense, the collegium has all the facts. If you feel his integrity should not be doubted, leave him alone. And tell the people this is a nonsense. The media is running a false story, or this is a false narrative, or whatever. So I fault it on many reasons. My take on this is a fit occasion for 2 things. For the collegium to have an inquiry, and that inquiry should not be an in-house inquiry, and I'll tell you why. The in-house inquiry is not good for the judge. If he is found guilty, everybody will say, yes, you knew it from day one, you only were buying time. If he is found not guilty and he has a good explanation, this inquiry will be flawed and alleged to be a cleanup operation. We've heard this about certain other in-house inquiries about judges. What is the problem in the Supreme Court appointing a judge and two eminent Indians to conduct an inquiry? And how long should this inquiry take? 10 days, because the allegation is cash has been found there. Either the allegation of cash being found is true or untrue. If it is true, the judge either has an explanation or doesn't have an explanation. And this can be resolved immediately. And if the inquiry committee comes to a negative finding and says that the judge has been unable to explain his sources, the Prevention of Corruption Act will deal with him. And if he explains his sources, an independent inquiry committee will put this matter to bed. So that's my take on this. That's how I feel. Because what is at stake is the public perception of the institution of the judiciary. The institution is on trial. And the institute has to vindicate public faith and public confidence.
But Mr. Salve, I don't want to get ahead of myself. I don't want to cast aspersions. I don't want to suggest anything that can get me into trouble, because the judiciary in this country, as you know, is above all kinds of inquiry. At least that's the signal we get from the bench if you raise too piercing a question. But what worries me right now, from what your response and your assessment of the situation suggests, is that the collegium itself has failed itself. And the High Office. Now, how does the collegium, who's going to hold that to account? That's led by the Chief Justice of India.
But that is why, Rahul, that is why I've always been a critic of the collegium system of appointment. It was a stopgap arrangement.
That I'm aware of.
To prevent the executive from packing the judiciary while we found an appropriate solution. The NGAC judgment, which says that unless it's a judge-dominated committee, the independence of the judges will be compromised, is simply wrong. There is no sociological evidence. All over the world, some of the finest judges are appointed by independent committees, not dominated by judges. So I do not agree with this at all. And the problem in this is a system must run with transparency. A collegium is not meant to be transparent. Judges must speak only through their judgments. And that is why we say, criticize the judgment, not the judge. If you criticize the judge, that's contempt. You can tear a judgment apart, that's not contempt. Now here, the collegium action is in public domain, so you have to criticize the collegium. And then you rightly are raising the doubt as to how far can I go. So this is why the collegium is not meant to be. It was a stopgap arrangement. This is the problem of the collegium. Can the Chief Justice of India come and address a press conference and tell us what is going on? Hope he doesn't. We've had the disaster of one former Chief Justice.
I remember that.
BBC journalist, and see what happened. But the problem is we need a system which can work in public domain to deal with incidents like this which have taken place in public.
But Mr. Salve, I'm pressing on with this question. I might get into trouble, but I'm pressing on with this question. Look, if the people within the collegium have not resolved themselves to act in a manner that appears to be robust enough, or at least meet the tests of judicial standards, then who is going to hold them to account?
So this is the two things. Can you hold yourself to account? The answer lies in the question. It has to be an external body.
Yes.
Secondly, can you as judges take on a function in which your functioning, not your decisions, will be the subject matter of public criticism? And then are you not crossing that line? You are coming outside your inner chambers where you take decisions and which you pronounce in open court. You are now asking us to go inside your rooms and want to know what is it that you discussed, who said what, and why did you come to this decision. Can't be a one-liner. If a union cabinet was to take action on a cabinet minister who had been found like this, could it have been a one-liner? The media would have torn it apart. Can a chief minister take this action for a minister caught with cash? You would have torn him apart.
Yeah.
Could a government have done this for a bureaucrat found with cash? You would have torn him apart. But you are now with kid gloves saying, how much can I ask? So that is why this whole system needs a relook. And I also make bold to say, I've said this before and I'm saying it again, and I know I'm whistling in the wind when I say this, but I will say it. I have voted for people in parliament to make laws, to fix what is wrong with our democracy. The political system, all politicians across party lines owe it to put their heads together. This incident brings to fore the fragility in the system. Put their heads together, have a consensus, come up with an institution for judicial appointments and judicial accountability. The time is now.
But you are aware that the NGAC was struck down by the Supreme Court itself. There was an act. People came together. All of this happened. And in fact, the Vice President today in the House took us back down memory lane and told us that the House sat together and evolved a consensus, and perhaps for the first time, even 16 states were taken on board, a bill was brought, passed, but then as you know, who set it aside? It was the Supreme Court itself. Now, how do you work around a conundrum like this?
I'm sure if there is political consensus and a bill with a minor tweak is brought before the court, the Supreme Court has revisited its judgments. Justice Chandrachud used to take pride in how many judgments he has reversed. This is one judgment which he could and should have reversed.
But Mr. Salve, there is a problem here, and I have to ask and I have to press on. The point is that if you have transferred somebody, then prima facie, I'm only saying prima facie, it appears that that person became inconvenient in some ways. And if he became inconvenient, at least this particular judge became inconvenient, a fly in the ointment, then it is a tacit admission that everything was not above board. Despite that, you had the collegium that did not take any of the steps that you are advocating. What does this mean?
This only means that the collegium, see, these are judges, they are very wise people, very learned in the law, but that sometimes is insufficient. The collegium felt, let's find a quick fix to this. I'm sorry, these problems would not be resolved by a quick fix. In fact, it only has made things worse. So, this is the problem. See, the transfer of judges for strengthening the judicial system. Sometimes you send a very strong commercial judge to a court which doesn't have strong commercial judges, or etc., etc. You move judges around to give an opportunity to some judges to go somewhere. That's perfectly fine. That's for the collegium, because you are administering the judicial system. But where it comes to something like this, transfer is not a solution. Are you trying to suggest that a person who's unfit to work in court A is fit to work in court B? And why? So, this is just, I think it was I'm sorry to use very strong words, but I think this was a blunder.
Now, could the executive have stepped in, or can Parliament even now step in, maybe move impeachment proceedings? Because, look, I have to say, in today's supercharged atmosphere, the executive will be accused, as you know, of trying to arm twist the judiciary.
Absolutely.
Put a knee or a chokehold on the judiciary. I don't know. I mean, what does the executive do?
See, that the executive is, to borrow the old expression, damned if you do and damned if you don't. If you don't do anything, they'll say you are very happy, you are corrupt, and you are like corrupt people around you. And if you do something, they'll say, you don't like the judiciary, you don't like this judge because he was anti-government, therefore you are putting a knee on his neck. The Parliament has to respond. You can make allegations against the executive, you cannot make allegations against Parliament. And Parliament has to respond across party lines. Let all MPs acknowledge that they all want honesty in the judiciary. And if you do, have a sit down and think of what structure you can have. Set up a committee, if you want, of Parliament to hammer out a structure. which will work consistent with independence of judiciary and yet achieve appointment, transparency in appointments, this good selection process in appointments, and accountability in appropriate cases. Please put your heads together. The country looks to you. Save the judges from themselves.
But that's a very important phrase, save the judges from themselves. Now, that's the question I want to come to, because you had mentioned that had this happened to a public servant, for example, the ED would have been knocking at that public servant's door. This is also a public servant, but of a certain different sort of stripe. Now, how would you have expected, let's say, okay, there's been a problem. This in-house inquiry, was there any other mechanism available to the Chief Justice of India or the collegium beyond this?
Let me answer you straight away, Rahul. There is a rule by which the police doesn't land at the door of a judge without clearance from the Supreme Court.
That's right.
And for good reason. That's a good check and safeguard.
Sure.
The Chief Justice could have immediately set up an expert committee, independent committee of 3 people, call the judge, hear his explanation, request the judge to take leave, or relieve him from judicial work. And it's been done in the past.
Yeah.
If you remember, there used to be a Justice Ramaswamy.
That's right.
Against whom there were allegations which, compared to your news reports, appear to be rather tame, that he had put some expensive curtains and carpets in his official home. Against him, Justice Mukherjee came into open court and read out a long order giving his reasons for why he was withdrawing judicial work. And he then set up an in-house committee because the issue there was about whether breach of the rules of ethics applicable to judges. Today's allegation is a large amount of cash, do the presumptions under the Prevention of Corruption Act apply, etc., etc. It's a very different question. You can have an independent committee who takes a view. Hear the judge's explanation. Maybe he has an explanation. Hear his explanation. If they say, an independent committee says, we have heard his explanation, there's nothing in it. If it is independent, he'll be believed. If it is only judges, you will say it's a whitewash. If that committee says he has done something wrong, then action is at 2 levels. One is, as a judge, what do you do? Obviously, you can't allow him to ever go back to work. If he doesn't resign, you take away judicial work from him. And then you hand it over to the law enforcement authorities. After you are satisfied that it's a fit case for the law of the land to apply. This is how you safeguard the judiciary and also maintain public faith. I think the faith of the people in the Supreme Court will be reinforced, and I'll be very proud of my court if it is willing to deal firmly with one of its own and with an even hand.
But Mr. Salve, look, all of this would be in an ideal situation, wouldn't it? The problem is that it's obvious that the explanation hasn't held any water. It's clear, because otherwise there would have been no transfer. The matter would have been resolved. They would have said, okay, we understand, maybe it was some money that you had inherited, whatever. But the point that a transfer has taken place is a subtle punitive action, which means that there is some wrongdoing. Now, my question is the collegium even interested in transparency? Look, I have to ask you this, and this is the second part. You've talked about appointments. I have a fundamental problem. As an Indian citizen who earns a salary, I have to declare every asset that I have been able to accumulate with my salary, with my earnings. But certain judges in the higher judiciary are exempt. They don't mandatorily have to declare their assets either.
So it brings me back to what I was saying. We need some structural changes to bring our judiciary up to contemporary standards of transparency. And these are evolving social norms. And a collegium cannot function with transparency because you cannot shine a light in the inner chambers of the judges, for the reason that there is a lot of work they do which must be done in secrecy. So the collegium is incompetent for is not geared for a transparent operation. Let me give you a small example. Suppose you are considering the name of somebody for appointment as a judge. You, the collegium, hear all kinds of rumors. You hear, and you should hear all kinds of criticism about the person. If you don't do it, if you do it secretly inside your own home and come up, people say, collegium, you're opaque. If you put everything and your reasons in public domain, I mean, if somebody says, why don't you make Harish Salve a judge? And then you hear 50 complaints against me, and you say, no, he's not fit to be a judge. And you put all this in public domain, you damned me without me never wanting to be a judge. So this system cannot work. You need a different system. That's as far as the appointment is concerned. As far as the accountability is concerned, any accountability in-house is a oxymoron. You can't say, I'm accountable to myself or we are accountable to ourselves. In today's world, that's an oxymoron. Accountability means there is an independent body which checks and corrects you and exonerates you, which exoneration carries credibility. And I repeat, the Supreme Court's strength comes from public perception in its honesty, fairness, and independence.
Now, are they... Again, I'm still mystified because, yes, now there has been a course correction. Now there is an in-house inquiry. That means that the collegium has accepted public criticism from notables like you and others who have said that their initial action wasn't up to a particular standard. Now you have an in-house inquiry. But I have to ask you this. Is there legal precedent that exists for dealing with judicial misconduct that perhaps has stilled the hand? I mean,
you pull yourself by your bootstraps as you go along because you don't have a system. And that is why all this trouble. Rahul, there are allegations of corruption in a number of cases. And as a lawyer, many times when I read a judgment, I know it's right, I know it's wrong, and I know this is for the wrong reasons. Okay? I can say that. So, and there have been whispers all along. No, they are very different. Today, something has happened in sunlight. It has to be dealt with in sunlight. You cannot take this indoors, lock the doors and deal with this. This has to be dealt with in sunlight. So this infection can't be cured in darkness. Now, there is no mechanism to fix this.
Yeah, so who takes the lead in establishing a mechanism for independent judicial, maybe like an independent judicial complaints commission? Who takes the lead?
So the immediate lead has to be, because the system can't be created in a day. So there is an ad hoc remedy, and then there is the crying need, which has been underscored by this incident, for having a system in place. The immediate problem has to be solved by the Chief Justice and his colleagues, and they are wise people with their heart in the right place. I have no doubt about that. But they have to put their heads together and come out with a system which satisfies public perception in the honesty of the court. In this case, my suggestion is do it by an inquiry in which there are two eminent citizens from outside. So at least it's in public gaze. And if they exonerate, that exoneration will go a long way for the judge. So do that. And in the meanwhile, I think the time has come once again for Parliament, I don't say the government, I say for Parliament, to put all their 500 heads together and find a solution to this problem. This problem is far too serious to be polarized on political lines.
Mr. Salve, my final question to you, and this is an important one. Let's assume that for some reason, people have a vested interest in not changing the circumstances as they exist today. I'm not imputing motives, I'm just saying. Would someone like you perhaps want to move court, file a PIL, etc., and nudge this system along?
This can't be resolved in a judicial proceeding. You file a PIL before a Supreme Court which is reluctant to change the system. It's not. This has to be dealt with at a policy level. If the political system cannot come together to save democracy.
I think that's a valid point. That's a very valid point. Well, thank you, Mr. Salve, for speaking to us, taking the time out. I appreciate your openness and your outspokenness. Thank you very much. You're a voice for change. Thank you very much.
I always feel, Rahul, when I speak like this, I'm whistling in the wind.
No, you're not. You're speaking with conviction, and that's really what matters, and God give you more power. Thank you very much. We need independent voices such as yours. Thank you. To be heard. Viewers, let's go straight